First of all, welcome to the latest in Ray's IP in Focus webinar series. This is the second set of webinars that are being offered. It's going to run over today and tomorrow. There's a couple more seminars that are going to be run. We've got Power of Searching happening later in the day. Then tomorrow, Essentials in your IP Toolkit, and making the most of your time with an IP expert. It's not too late to get involved with one or more of those if you wish. Okay, now obviously you're familiar with Ray's, you're here on our webinar, but obviously we are one of Australia's largest independent IP and law firms, and we've been here in Western Australia since 1920. And since the noughties over on the East Coast, and we're very pleased to have you watching with us today. My name's Peter Caporn. I'm a principal in the chemistry patent group here at Ray's, and this person sitting on my right is Mary Turonek, also a principal in the Ray's chemistry group. Welcome, Mary.
Yeah. Good to be here, Peter.
Okay, well, look, I'm going to throw to Mary to do much of the talking today, and I will chime in and add a little bit of value here and there as I'm able. So over to you now, Mary.
Okay, thanks very much, Peter. And thanks for joining us, everyone, this morning. And look, you're here to find out a little bit more about how to manage IP costs in a crisis. Today, I'm going to focus mostly on patent costs and management of patent costs. But I think Peter is going to come in with some words of wisdom about trademarks and design rights as well. But generally speaking, the patent system involves very large costs over its life cycle. And I think, as we all recognise, well-managed IP represents one of the most valuable assets that a company may hold. It can increase revenue, reduce business costs, improve the market position, and attract investment. But like any other business asset, there are costs associated with acquiring those assets and maintaining the IP rights across their life cycle. So in difficult business conditions, as we're experiencing now, particularly when cash flow is limited, it is tempting to make visceral decisions to minimise all expenditure across the board. But in our view, I think intentionally deciding to jettison IP rights because of ongoing costs, it may be misguided and short-sighted. Loss of businesses' IP rights may be actually worse in the long term for a business going forward. It may be worse than actually losing tangible assets, because tangible assets can be repurchased, employees can be re-employed, but intangible assets such as IP rights, once they're abandoned, that's it. You can't re-establish those rights and bring them back into the business. So in this article, in this presentation, we want to provide some tips and strategies to reduce IP spend in the three major stages of the life cycle of patent rights. So the establishment of patent rights, which is filing, obtaining enforceable patent rights, which we term as prosecution, and then the maintenance of those patent rights once the patents are granted. So we see it as sort of ensuring that significant value is not lost in the short term, and so that enables businesses to be better positioned when market conditions improve. So some comments about how businesses can save a bit of money even before they decide to file a patent application. Certainly in terms of preliminary searching around the invention, that can provide some very useful information about the novelty and patentability of the invention, certainly about the landscape, the patent landscape in which this new technology sits, you can save a lot of money in terms of being able to hone in on what the invention is and avoid prior art. I think it's also very prudent, not just in cash-strapped times, but in any time, to be able to identify the inventors up front and make sure that there are confirmatory assignments in place, and that you're able to confirm the entitlement to patent rights right at the outset.
Mary, I might jump in and just say very quickly, look, much of that is the same from a trademarking point of view. Searching is terribly important early on in the trademarking process and can save a lot of time and cost down the track if done properly at first instance. The general trademark process is similar to that that Mary's explained for patents in terms of filing, prosecution, onto registration or grant, and subsequently maintenance over time. Interestingly, with trademarks, that can be indefinite, unlike patents, which are for a set period of time or having a maximum term. Okay, back to you.
Okay. So if you've done some searching and you find that the technology is patentable in its own right, or at least it looks that way at the outset, I think, you know, look at the economic conditions, and if there are commercial plans to roll out new products and services, if they're going to be delayed in, you know, poor economic circumstances, then it might be justified to similarly delay filing those patent applications. But if nevertheless the business is forging ahead with commercialisation programs, then it could be short-sighted to neglect to acquire that patent protection before you have public disclosure of the invention. So we're going to talk now a little bit more about, well, how can we reduce the costs or minimise those costs at the drafting stage, which is where a lot of the upfront costs are incurred, because it's a very time-consuming exercise to draft a detailed application in relation to an invention. And I think drafting costs are more likely to be contained if businesses, again, do their homework and provide as much detailed information about the invention to their patent attorney to streamline those drafting activities. It really is all about streamlining and minimising the amount of time that's spent by your patent attorney in drafting that patent application. Now, I do want to sort of dispel here and now that it's probably a waste of your time to draft your own patent application and then hand it to your patent attorney and ask them to amend it, because more than likely we will have to start from scratch all over again. But I think providing detailed information about what the invention is, what it does, how it performs, what are the problems in the art that it's trying to solve, and look at, if you can, putting on a crystal ball and looking into that crystal ball and looking at how your competitors, what they might do to use alternative features to work around your patent. If you can think laterally about, well, how else might I do this? Providing all of that additional information will assist patent attorneys to streamline that drafting process and ultimately provide you a robust patent specification, because we not only will be able to cover the commercial embodiment of the invention, but some of these alternatives and possible workarounds that your competitors might have. I think if a team of inventors is involved in the development of the invention, then appoint a single person to review the patent application, or at least a coordinator to collate several internal reviews, so that a single set of proposed amendments and modifications is forward to the patent attorney. And this will avoid set of circumstances where you're undergoing multiple revisions and amendments by the patent attorney in the preparation of your patent specification. Work with your patent attorney to prepare drawings internally if you have that capability in-house. And I think, tailor also the number of independent claims that you have in your patent application. Discuss that with your patent attorney and work out what you actually need. And this is an important exercise because in some jurisdictions where you may wish to file patent applications, there are excess claim fees that are payable if you have an excess number of claims. So discuss that with your patent attorney. That will be part of the discussion that you would have around your filing strategy, but take that into account in the drafting of the patent application as well. And this will help you to reduce your costs. Look, in Australia, it's usual practice to file a standard patent application 12 months after the initial first filed provisional patent application, and to either file corresponding national patent applications in the countries of interest to you, or to file a PCT patent application under the Patent Cooperation Treaty. The PCT allows applicants to cover potentially over 145 different signatory countries. And the other advantage of filing an international PCT patent application is that it delays the time by about 18 months in which you have to make a decision to file in different national countries. So there are two advantages there. First, there's a deferment of the costs associated with a national filing program. And secondly, it provides the business to consolidate its commercial plans and its marketing plans for the technology in those countries. And I think you can enter a national filing strategy with a lot more confidence and potentially save money by not filing patent applications in countries that perhaps you will jettison later on because there wasn't enough merit in filing those applications in those countries.
So Mary, that gives a period of 2.5 years essentially from when you first filed a provisional patent application directed to the invention, and perhaps then you've had through that initial 12 months of provisional protection, you had some update provisionals filed because perhaps there were some improvements or modifications that you wanted to capture. Again, you can file update provisionals through that initial 12 months to cover off on those improvements before you have to then make that commitment around filing the PCT or international patent application. In the 30 years that I've been doing this, the decision to file a PCT application now is almost entirely across the board for patent applicants with any interest in filing overseas.
Yes, that's my experience also. And look, the entry to national phase stage of the PCT patent application, it does incur significant costs associated with filing applications in multiple countries. In some countries, there'll be translation costs and there'll be additional administration costs such as notarization of documents, legalization of documents, because they're required in some jurisdictions. So I think when you're about to embark on a national filing strategy, you really have to look at it carefully because the costs can rapidly escalate. And we would advocate careful selection of countries, which is based upon your commercial strategy. Align that national filing strategy with your commercial strategy and you will optimize the value in your IP rights, unfortunately. So, we think carefully select those countries in the national phase based upon, a whole number of attributes. What is the market size? What is your current market presence in that particular country? What is the competition? What's the potential for market growth, the likely market growth? Where are the location of your manufacturing centres? What are your competitors doing and their filing strategies? Take learnings from those the ease of enforceability, and again, you know, look at the translations. If you're going to have a national phase filing program that's centred in Latin America, for example, you're going to need translations in Spanish and Portuguese for Brazil. If you've spent the money on one translation for example, Chile, then it may be more cost effective to also cover Peru at the same time, because you have that translation that you can use in that particular country, if there are commercial reasons to do so. Okay.
Mary, I'm constantly surprised by how many people get towards the end of the PCT process, and we ask what countries do they wish to proceed in, and they seem surprised that they're going to have to make a decision about that. So it does pay to be prepared in terms of knowing where you wish to go to get the outcome that you desire. The other aspect to perhaps consider is if you have a commercial arrangements with anyone, what their expectations might be, where protection might be obtained.
Yeah, and look, I think the timing for those sorts of discussions within your own business is probably about 3 months before your national phase deadline, because that gives you sufficient time to discuss all of those issues within the business, and then to have a discussion with your patent attorney. We can reach out to the number of associates that we have around the world, try to get the best price for you in advance. But if we get instructions right at the last minute, it's very difficult to negotiate a good price with our foreign associates for our clients. So doing your homework and being prepared up front, well in advance, is certainly a good way to move forward and save those costs and streamline the process. Okay, look, if cash flow is really an absolute obstacle to proceeding with national phase entry, one strategy is to defer these costs by withdrawing the claim to priority. And I've got some timelines up on the screen now. You can see that in the conventional timeline at 0 months, that's the earliest filing date of your Australian provisional patent application. Typically, your PCT application will be filed 12 months later, and the deadline for national phase filings is 30 months from the date of your Australian provisional patent application. So that's a full 2.5 year period. That's set in stone. We can't extend that. We have to work within those timelines. But if at that 30-month deadline you are unable to come up with the funds to fund a national phase filing deadline, or you're waiting on investors, to make up their minds, it is possible to withdraw the claim to priority before that 30-month deadline expires. Now, it's a risky strategy, and it will be dependent upon a number of factors. But what will happen is that by withdrawing the priority claim, your 0-month timeline commences at the date of filing the PCT patent application, and then you get 2.5 years or 30 months from the date of filing the PCT application. It is a risky strategy because it opens the door for third parties. If they've later filed patent applications, perhaps at somewhere in that period there, between 0 months and 12 months, then they will predate your later filed PCT patent application. So that is a risk for you. I think also you must be very wary if there's been any disclosure or commercialisation of the invention after the filing of the provisional patent application, but before their PCT patent application filing date, then that is very dangerous to do because you run the risk of invalidating the patent for prior disclosure of your invention before its filing, before the filing date. And while there are, some grace periods allowable in some countries, there are others which depend upon absolute novelty, and you will have blown your patent application out of the water.
There's absolutely no value in withholding information from your patent attorney at that point in time. It's an issue that won't go away and can, cause significant issues in the future if not disclosed and considered in terms of the filing strategy that's been discussed.
Okay, so look, I think we'll go on to now prosecution, and there's probably, on this slide, there's two key strategies to cutting costs during prosecution without losing patent rights. And the first strategy is to defer or delay actions where possible. And by this I mean, requesting examination or responding to patent examination reports, because they will always incur fees, official fees and costs of your patent attorneys here and overseas. So try to extend those deadlines where possible, except where the extension fees are prohibitive to do so. And the other strategy is perhaps a bit counterintuitive, because it's the goal of everybody to obtain granted patents. And it's a milestone to celebrate, but it can be associated with significant costs. So for example, many countries, when the patent is granted, there's back payment of renewal fees, which were due and accumulating while the patent application was pending. And in the case of Europe, the grant of that European patent can be expensive because there are translation fees associated with translating the patent and the specification, validation fees, etc. So, delaying the grant of that European patent can, in the short term, save you some money if cash flow is an issue at that particular time. So, one little hack is to request correction of the European patent text, some minor amendments that aren't going to change the scope of the claims at all, or the subject matter in the description. And what will happen is that it'll just delay that date for grant by a few weeks, a couple of months. Okay, again, similar to our discussion upon drafting, minimising the amount of time that your patent attorney spends on the prosecution of your patent applications during examination is going to save you time. So I think, first of all, we maximise the learnings that you have from corresponding patent family members. Similar prior art documents are likely to be cited by different national patent offices. So if it's appropriate, under the national patent laws in that particular country, use similar arguments and claim amendments to minimise the amount of time that's spent in drafting submissions and arguments that are going to overcome the objections that have been raised against your patent application. And try to avoid, if you can, multiple rounds of submissions and fighting over nuances in the patent claims. Sometimes it's just better in the long run, or certainly more cost effective, to concede to narrowing claim amendments just to get it through to grant and not have to be backwards and forwards with the patent examiners arguing over, small points. Peter, have you got anything to say?
No, I agree completely on that. It pays to be pragmatic in how you approach your prosecution, argue the big points and concede the little ones where you can without too much impact. And it often helps a patent examiner feel like he's getting his way with, and you focus on the big issue.
Yeah, know which battles to fight.
Yes.
Yeah. Okay, the other tip that we'd like to tell you about streamlining prosecution is to engage in modified substantive examination where it's available, or use the patent prosecution highway. And this diagram on the slide shows the interconnectedness now of a lot of the patent offices, so that if you're able, for example, to obtain an allowed patent application in Australia, for example, and you have a corresponding US patent application, a European patent application elsewhere around the world, Singapore, for example, you can apply for expedited examination on the basis of your allowed patent application in Australia. You point out the allowed claims and the similarities of the correspondence with your claims in your US application or European or Singaporean application, for example, and the prosecution of that application will be much more streamlined than if it had been examined on its own merits.
Yep, look, that's a definite. We see that day to day. Look, I mean, you do want to consider with your attorney what the implications of that might be in terms of perhaps you ending up with slightly less breadth of protection than you might have otherwise achieved, but it's definitely a discussion that you should be having with your attorney around the whole prosecution strategy.
Yeah. Okay, moving on now to maintenance. Look, it's quite shocking in one way to find that about up to 75% of the total estimated costs of your patent across its 20-year life cycle are due to payment of renewal fees. And I think the cost burden for payment of renewal fees is compounded if a patent family has several members in different countries, because those fees for each of those members are due on exactly the same day. So with limited cash flow, it is possible to take advantage of a 6-month grace period for payment of renewal fees, but ultimately this only delays the inevitable, and it will lead to increased costs in the end down the track because there are penalties for late payment. However, if cash flow demands are such that you must resort to taking advantage of the grace period, those additional penalty fees can be mitigated to some extent by staggering payment of your renewal fees across the 6-month grace period. So you would pay for the renewal fees of patent applications earlier in that period where the extension fees are prohibitively higher, and you know, leave the others that are cheaper to later in that grace period. And again, you know, I think the key message here is discuss your issues with your patent attorney. We will work with you and look for the best ways in which we can save money and yet still retain those rights for your business, because that's what we do, you know, and we are problem solvers, and we'll go to that extent to make sure that you're able to retain what you can as far as possible within the budget that you currently have available. Okay, look, I think a word of warning again, look, it is a risky strategy to use the grace period, and I think particularly that staggered approach that I was talking about, and you must diarise when those fees are due so that no rights lapse unintentionally by missing that 6-month grace period. Look, an upcoming deadline for payment of renewal fees is also a very opportune time to assess the current and the projected future of a patent family or a patent in a jurisdiction where its market value is not sufficiently defined. I think you have to be strategic and mindful of the IP position needed in the future when normal operating business conditions resume. So, you know, although abandonment of patents can generate savings in the present and future expenditure, the decision to abandon patents, I think, should be taken with a view to retaining long-term value. And you can remove dead wood at the same time from the patent portfolio. So, but, you know, maintaining long-term value has to be the main consideration. So, you know, some of the factors that we think are a good idea to sort of, ask those questions about, well, what are the attributes of my patent portfolio? And the first is age. The older the patent is, the higher the maintenance fee it's going to attract. So look at what return it's generating, and is it justified in retaining a patent that's 19 years old and is not delivering the returns that it once was. Okay, it may have been superseded by later filed patents in your portfolio that are better aligned with technology improvements or current market offerings. So look at the older patents in your portfolio first. Then turn to the geography and looking at whether maintaining patent protection in some countries, is it economically viable if commercialisation efforts have not gained sufficient traction, or the market size hasn't developed in the way that you thought it might and doesn't provide a return on investment. I think, again, take a long view. Patents have a 20-year term, and rapid market developments can impact on the perceived value of a patent in that country. So it's important, I think, to do some homework in relation to those markets and ask advice of government organisations, Industry, Trade, and because they'll be able to provide you with some detailed information about the market conditions in the countries where you have those patents, and have those honest, open conversations with people who have expertise to allow you to make the right decision. Okay, in terms of market performance, look, that's just looking at, well, how has the market received the technology? Has it really gained traction, increased competition, and have you gained a larger market share? And if it's not performing in the way that you hoped it would, then sometimes that's the time to make the hard decisions and to can it. I think as an alternative to abandonment, it's also useful to consider if the IP might be potentially valuable to a third party and whether it could be licensed or sold to generate a revenue stream. So think about that. We have people here at Raise who can have those discussions with you and prepare, if you like, some documents which are going to sort of market and commercialise those to third parties.
Absolutely.
Yeah.
Now, look, that's the end of the presentation proper. Now we've got a little bit of time for some questions. Let's just bring those up and see if we have any. I probably should have invited questions right at the beginning of the presentation, but hopefully you've taken advantage of the Q&A facility. If you can click on that.
Yeah. Yeah.
You need to click that button, or
no, that's
no?
showing
okay.
up.
So that will. There's
No,
no open questions at this
yeah.
stage. Sorry, you can see I'm a little unfamiliar with the technology. Thank you. Look, I'll quickly add while we're waiting to see if there are perhaps any questions that are put forward. Just around trademarks. Look, the strategies, in addition to searching, that are recommended at the beginning of the process are, when filing in Australia, there are some options. You can choose a head start application, which is a way of paying only half the fees and getting an early opinion out of the trademarks office as to the registrability of that mark. So that can save you getting into trouble in adopting a mark that is otherwise unregistrable. Also, when filing, you can choose to use what are called pick list items. And if you choose from the trademark office's specific pick list, you can actually save some official fees at filing. And the other time to consider some strategy issues are around international filings. If you're looking to obtain trademark protection overseas, which is more and more recommended these days as markets open up to Australian traders. It's very easy to trade overseas now compared to how it used to be. So there's an international trademark registration available, which may be an appropriate option to consider rather than simply obtaining trademark registrations in each individual country independently.
Okay, we've got a couple of questions now about government grants. Are there any government grants which can be incorporated in IP strategy to help cash flow? Well, I'm aware of the Export Market Development Grant, and you can specifically claim the costs for patents, for trademarks, for registered designs in countries other than Australia, because they're supporting the export of goods and services into other countries. And I think they're awarded on a one-to-one basis. So, for example, if you spend $20,000, for example, on an IP program, then the government will effectively refund $10,000 of that money. So that's a fairly decent help. The R&D tax rebates aren't specifically claimable for filing and establishment of IP rights and trademark rights.
Yeah, interestingly, you know, patent protection isn't seen by them to be part of the normal cost of doing business, which, you know, is an argument that I think is ongoing in many respects.
However, I mean, we've provided support to R&D tax consultants in the past in relation to programs where applications have been made for the grant, and they've been knocked back by Oz Industry because the program itself wasn't regarded as being novel and new. And as patent attorneys, we've undertaken novelty searches to demonstrate that the technology is new in comparison to what's out there already. And that's been very helpful on occasion when there have been difficulties in obtaining that R&D grant. So from that point of view, an IP professionals can be of assistance in those, but specifically the IP rights aren't included in the grant.
And there are a range of other federal and state-based grants or schemes that do provide for some support for IP filings. I won't name them all now. There's a range of advisors that we typically work with who are able to provide detailed information about all of those. But as you'd imagine, as innovation has become more and more of a buzzword, there is more and more support out there for those wanting to get protection and wanting to build businesses in particular around new technologies.
Yeah. Okay. Well, thank you very much for joining us this morning. I hope our words of wisdom have had a little bit of value and hit home with you, and you find that useful in your own deliberations. And I think the takeaway message this morning really is to work with your patent attorney and do your homework. Your homework can help, and be prepared.
Yes.
Yeah. Okay. Great.
So thank you very much.
Thanks for joining us.
Any questions later? We're more than happy to take them. So please don't hesitate to get in touch. Thanks for your time.
All the best. Bye-bye.